And it is time for another installment of Martial Law with Marshall Chriswell this morning, and this program is intended for informational purposes only. The information does not constitute legal advice. The law is constantly changing. The information may not be complete or correct depending on the date and your particular legal problem. Each legal problem depends on its individual facts, and different jurisdictions have different laws and regulations. Because of that, you should not act or rely on any information in this segment without seeking the advice of a competent attorney, licensed to practice law in your jurisdiction for your particular problem. And certainly Marshall Chriswell is among that fine roster of folks, and we join him this morning. Good morning to you.
Hey, good morning, Todd.
Good to have you with us here today. We struggle sometimes with adapting to different technologies as they become more commonplace in our society. And one of those is the use of technology to sign your name and to do certain actions that in the past we would have to actually sit there in person and do. And in this particular case, we're talking about electronic signatures and their use. And a recent Superior Court decision here in Pennsylvania addressing just that in terms of your will. Tell me about that.
Sure. Yeah. Back up prior to the COVID-19 pandemic, of course, methods of signing documents digitally, electronically, had already taken hold in many respects. You can you can sign contracts, you can sign purchase orders, you can buy things and sign your name digitally online. To do so, had already become commonplace, but in the legal realm, as far as signing legal documents, it had not kept pace with the rest of society in that respect. And the COVID-19 pandemic did a lot to drag lawyers kicking and screaming into the digital age when it comes to signatures. And because obviously we just couldn't conduct business in lots of situations because we could not have people get together. So the Commonwealth of Pennsylvania, the legislature, and the Pennsylvania Department of State all got together and created a process called remote online notarization, because this was the biggest sticking point as far as signatures that needed to be notarized, and you've got to physically have a notary there, of course, and the purpose of the notary is to confirm the person's identity that's making that signature. So the state created this remote online notarization process where you actually have somebody on video conference, the person that's doing the signatures on video conference with the notary. They've both got physical copies of the documents in their hands, and that you go through a physical and electronic verification of the person's identity, and then you can do a notarization of their signature that they physically sign. The person physically signs it where they're at, and the remote notary puts an electronic stamp, a signature notary stamp on it. So that started to become more commonplace during the pandemic for all sorts of documents. We could conduct a real estate closing where all kinds of documents need to be signed, up to and including a deed. And these things could be done remotely. Well, it remained to be seen whether a remote signature for a last will and testament would be considered valid, particularly by the appellate courts in Pennsylvania, and we now have an answer. Mm-hmm. In the estate of Kittler, out of Lancaster County, very recent decision filed on September 25th last week. We have a situation where it was a woman. It was during the COVID-19 pandemic. Okay, she was diagnosed with late-stage cancer, and she wanted to create a will. She was in a nursing facility. She could not have the attorney and the witnesses and the notary public come in to the facility. So the attorney decided to use a remote online notarization process with the witnesses the witnesses sat in his office. You have two witnesses when someone signs a will. So he sat with the two witnesses in the notary. Ms. Kittler sat in the nursing home. She had the video chat on, and they used it. They used the program to a T. They every requirement, every box was checked. They did it exactly as it was supposed to be done, and ultimately the Superior Court says no way. It's got to be an original signature on a will.
Wow. Well, and Superior Court, of course, is an appellate court, which meant someone appealed, correct?
That's correct, and it was an appeal from the decision of the so what happened was that whenever you go to file a will, when you go to register a will after someone passes away to open an estate, a probate estate, you take the will into the county register of wills where the person resided. So in this case, they went into the Lancaster County Register of Wills, presented this will, and the evidence along with it to show that it's valid, and they were denied at the Register of Wills. The Register of Wills staff person there said, "Nope, that's not an original signature. We can't take it." They appealed it to the county orphans court. The orphans court agreed with the Register of Wills, so then they appealed from there. So we don't in this case. The interesting thing here is we don't have any family members that are disputing or fighting. I believe the son who was to inherit under the will. I don't know all. Actually, the opinion doesn't get into all the details, but it's clear that there was no controversy. The evidence was uncontroverted that this was what her intent was. The woman who had cancer and passed away, she had multiple phone calls with her attorney and her financial advisor, detailing exactly what she wanted. There was no question whether she was competent or not. So there was no family dispute here. It was just the court saying, no, we're not going to accept the will, and the family saying, we're going to appeal it to the Superior Court.
Okay, so without getting into the ultimate outcome of what that case will be, let's talk about the overall meaning for folks in your line of work, because there are certainly ramifications from this Superior Court decision. What does it mean?
There are, and I've seen, when we talk about electronic signatures, it can mean, everything from this remote online notarization process, which is a highly structured and regulated process that you can use, to something like a signature through an online signature like DocuSign or Adobe Sign or these things. Or I've even seen folks try to sign their will just, typing it up on Microsoft Word and then using the script font, right, going to a cursive font and then typing their name in and saying, okay, here's my will. Pennsylvania law, the statute is very clear, and that's why the decision was the way it was in this case. Pennsylvania law is very clear that a will must have the signature of the testator, the person making the will. It must be signed by the testator at the end of the will. Doesn't necessarily have to have witnesses. Doesn't necessarily have to be notarized. Just has to be signed. So, interestingly enough, in this case, if the lawyer would have drafted the will and just sent it to the nursing home, mailed it in, or had the son walk it in to his mom, and she read it over, and they had a phone call or a video conference about it, and she would have just signed it, it would have been totally valid. So, don't try to get. I guess the takeaway is, you've got to have a real wet signature, original signature on the will. Don't try to get cute with it. We don't care if your handwriting is bad. Don't use the online script version of a signature. You've got to have an actual signature on a will, and that's the way it's going to be until the Pennsylvania legislature enacts law otherwise. And there are about half a dozen states that have enacted what's called the Uniform Electronic Wills Act, and that does permit for the type of remote notarization and will signature that was done here. Pennsylvania doesn't have it yet, and the legislature is not even on the table for consideration at this point. So you've got to, if you're going to sign a will, you're going to sign these estate plan documents, got to be a wet signature.
And I guess from that particular attorney standpoint, don't try to assume that the law someday is going to catch up to you, and the actual law that as it's written is going to change and adapt to what you have done. Don't put the proverbial cart before the horse.
You're exactly right, and you can see from this attorney's perspective, this remote online notarization process was widely accepted across Pennsylvania during the pandemic, and it's actually was probably more secure than like I said, just sending the will to the nursing home and telling her, hey, sign it and send it back to me. Yeah. But you're absolutely right. You can't make assumptions.
All right, so do it in person, and as long as we're on this subject in our final seconds here this morning, Marshall, probably do it now is a good idea as well, isn't it?
That's always a good idea. As we've discussed, there are way too many people out there that don't have any kind of a plan in place or have estate plans, wills, and things that are way outdated. It's always important to get that done.
All right. So if you're going to make that call to Marshall Chriswell and get that process started and get your will in place, what should folks be doing?
You can give me a call, 724-465-5826. You can go online to www.westernpalawyer.com or come see us in the R&P Building, 655 Church Street here in Indiana.
There you go. Now, we're actually going to see you on Wednesday here as we talk about another thing coming up completely off this topic. You're here for Bethany Chapel. You've got a fall festival coming up, right?
We do have a fall festival coming up. It'll either be me or the pastor, Brian King, with you on Wednesday, but can't wait to have the opportunity to talk about that.
Wonderful. Hey, thanks for being with us today.
Okay, thank you. Take care.